Okay. Welcome to the Board of Health hearing on June 17th. Before I open the hearing, I would like to ask Vanessa, our new office manager, to do a quorum purpose call. Roll
Tom
call.
Lee,
Present.
Dr. Guadagnoli. Present. Dr. Lesko,
Present.
Dr. Caniff,
Here, present.
Dr. Beer, and Dr. Waller is absent, and Health Director Tom McKean.
Here. And Vanessa Tripp is our new office manager.
Right. You're welcome. This meeting is being recorded and broadcast on the Town of Barnstable's Government's Access Channel. In accordance with the Mass General Law, Chapter 38, Section 20, please let the chair know if anyone is recording this meeting. Seeing none. The first item on the agenda is septic installer approval. Sam Dunford, septic installer, representing S.H. Dunford LLC, 91 Blue Rock Road, Yarmouth, requesting approval to become a licensed septic installer in the town of Barnstable. Is Sam here? Tom, is everything okay on this?
Yeah, Mr. Dunford passed our local exam, and his 3 references were good, so we have no objections.
Okay. Any question from the board member?
Move to approve. Second.
All in favor?
Aye.
Approved, thank you. The second one is tobacco hearing. David V. Laura, PC, representing CB Perkins Cigarette Lounge and Bar, 649 Main Street, Hyannis, map parcel 308-134, requesting formal appeal in connections with Mass State Code 105 CMR 665-010D, minimum standard for retail sale of tobacco and electronic nicotines delivering systems at licensed smoking bar. Dave?
You're all set.
Dave?
Yep, I'll be right up.
Okay.
I thought I had a little bit more time, but that was so quick.
You never know. You don't know the schedule in any hearing.
I should know better after all these years.
I just want to get a little organized here because I noticed there was an extra member, so I was trying to get another packet together.
While we're waiting for Dave, I just want to mention anyone coming up to do the, whether to participate in the hearing or making public comment, when you come up front, please sign the attendance sheets. Make sure you print the name so that, Vanessa can read it.
If I may approach.
Yes.
Thanks, Dan.
Do you have an extra copy?
I do, I
I have an extra copy here. And I have
Allison, do you want one?
one more if we have it. Sorry if I'm short. I meant to get one for you too, Tom. Sorry.
It's okay.
Copy you one.
We can share.
I can bring one electronically to you, Tom.
Sure.
Yeah.
Either way, it's fine.
So, let me, David Lawler, on behalf of CB Perkins Cigar Lounge and Bar. And there's a little bit of a history here, and I want to go through that because, quite frankly, I was a little surprised. There was a hearing in March, on March 22nd, and I've been representing this outfit since I think it was its inception in around 2001. I was the one to obtain the original cigar license back for the prior owner, David Wood, way back when, and then involved in representing the new owner since then. And by way of history, the statute was enacted with respect to General Laws 270, Section 28, with respect to the cigar lounge exception on the flavored tobaccos. Now, at that time, there was a violation before the board in 2022. And I think it was March 22nd, to be precise. And at that time, I was here and I presented before the board, and some of those documents are contained in this package as well, where I pointed out that there was a dilemma in the CMRs with the sale of what are called, quote-unquote, onesies, one cigarette, where it's illegal to sell one cigarette, and I also made the argument that to think someone would consume 20 cigarettes at one time would be not only it would be extraordinarily unhealthy and something that would be consistent with this board's mission. And we went through that, and this is very important, and we had a hearing. And where the hearing was on the violation, and at that hearing, a determination was made by this board. Two of the members of this board were on three of the members on this board were at the time. It was a three-member board. It was Chairman Lee, Dr. G, Dr. Caniff, and there was a vote. And there was a tremendous amount of discussion back and forth. And I want to be careful that the Commonwealth was here, council was here representing the Tobacco County Board, and there was an attorney who's here present today, Attorney Sabar. And they came up and they argued diligently back and forth on behalf of their position with respect to what should happen. And I argued back and forth. And part of the issue is that this is a statute which requires interpretation. And I watched the meeting on March 22nd of this year. Now, council got up and spoke and said, well, this is what the law is. I suggest to you that this legislature and this board determines what the law is. That's an argument by a lawyer. Argument on one side, he made a cogent, intelligent argument. And back in 2022, I think I did the same and prevailed. Now, the history here is that, I suggest to you that Mr. Coletti, for whatever reasons, has continually, and the board, gone after this particular lounge. As one of the exhibits, two of the members that aren't here, and I included the photographs just to kind of refresh your memory, Exhibit E, where Mr. Coletti had decided to do a sting operation back in 2023. And during that sting operation, if you remember, the person he utilized basically committed a fraudulent act where he bought a vape. And if you remember, I had the video and showed it out clearly where he took the vape, hid behind the cash register, stuck it unopened in his pocket, and simultaneously pulled out a second vape and smoked it right in front of my client. Unknowns to him, we had video surveillance of the shop that showed not only did my client do everything appropriate, but in fact that this individual essentially committed a fraud, and I think the board unanimously declined the allegation, and I suggest to you the minutes are a little gentle when you read the minutes about what happened. I think that the indignation of the board members of what occurred was very evident by watching the video. So going back to the March 22nd meeting, we presented, cogent arguments as to why interpreting why one could, enjoy a flavored tobacco product partially on site and then remove the rest of the package. And there was conversations about the impracticality of lockers. One of the concerns is what happens if you have a locker in there? What happens if someone's storing an illegal gun or drugs in there? I mean, there's so many implications about having lockers. So Then we go after the, historically, we come to March 25th, and again, I had no notice of this particular hearing. And Mr. Coletti was present with an attorney from the Commonwealth, Christopher Bathen, who I indicated previously. And what's interesting about that, he gave a brief history of the law, and he did say that the history of the law was to prevent minors from obtaining products. However, that was just the history of the statute. Now, we have been in business since the law began and have been operating legally under your order since March of 2022, 3 years now. And not once was an issue of minors getting tobacco products discussed. It was all about being harassed by competitors or unfair competition. And I suggest to you, you find any case law where it's the duty of a Board of Health to regulate competition from any businesses in the Commonwealth. It's irrelevant. It's not before you. Whether or not it's true, and even if it was, I mean, the competition of a cigar bar and lounge, they have to maintain seats, they have to have an opening where a retailer can open up a store in 800 square feet and has virtually no cost. The cost and expense of operating an operation like C.D. Perkins is far greater, but it's irrelevant. It shouldn't be before you. It shouldn't be a consideration. Your consideration is the health and welfare of the members of Barnstable. Now, this is the issue. And I listened to Dr. G at that hearing say, well, we have to follow the law. Well, the law was presented to you by one side at that meeting and not the other, okay? And now there's a fair opportunity for both parties to discuss this. I want you to, and I presented a brief that I drafted today, that I provide the case law where what the law is. And this isn't the law of necessarily the Board of Health with respect to the statute, but this is a long-standing provision that governs boards of health in the Commonwealth of Massachusetts with an issue called issue preclusion and claim preclusion, things like that. Before you, on the 22nd of March 2022, there was a hearing. And at that hearing, you rendered a decision. Commonwealth was there. The county was there. There was discussion by Mr. McKeon about consulting lawyers. They were on notice of what occurred. They clearly were on notice of what your decision was. Your decision was recorded. It was accepted in the meetings, the following meeting, or second meeting, and it was never appealed. They have 20 days or 30 days to appeal that decision. It is now 3 years. At March 22nd, nothing new is before you. There's no new claim, no new evidence, no new suggestion of what's going on before this board, but for the existing appeal. And let me read you the case log. I'm going to read the entire paragraph, second page. The 22th order was a quasi-judicial determination by the board reached after a full hearing and became final when no appeal was filed. The proper remedy for any aggrieved party was to file a timely appeal within 20 days as required by General Laws 40A, Section 17, CMR 760, CMR 5603. The board or any other party failed to do so. The result is that the order remains binding and enforceable. As stated in the Potter versus the Board of Appeals, Mansfield, and then I give a cite, 1973, once a board decision is filed and not appealed, the board loses jurisdiction to alter or to revoke it. That's the law. Then I provide you the other. Similarly, in Harborview, 100 Mass, 2021, the appeals court held that the town could not initiate a new enforcement order or proceeding arising from the same facts where the prior decision has not been appealed. You do not have the authority to overturn yourself. You made a ruling. There's nothing new before you. That's the law. I heard Dr. G say, we're going to follow the law. That's the law. This board, they made a decision for whatever reason. They chose not to. They had qualified counsel. I know, I believe Attorney Sabai is one of the top Board of Health lawyers in the Commonwealth. They were here. They knew they had an obligation to appeal it, and they did not appeal. They cannot now come back under no new set of facts. And the reason they don't have any new set of facts is they can't find them because they keep trying to set up sting operations. They even bring in someone who's willing to basically break the law and try to deceive this board and come in and do a phony almost like three-card Monty, coming in and switching out one vape for another. The reason they're trying to do this now is that they have attempted to find out if my client's breaking the law, and they haven't. They don't hire, it's a family operation. Could you please stand? They don't hire employees to work there where they'd love to. They close down because they're afraid an employee will not follow the rules. This is a family business that relies upon this. There's not been an allegation that this is somehow getting to the hands of children. These people, this is in business for 22-something years. There's never been a violation of a minor sale, this owner or the prior one. These people are absolutely diligent. I remember in 2022, then Chairman Norman said, if there's a violation, we're going to drop the hammer. Dr. G, you said, I am not going to be forgiven if there's a violation. And you said, not in 2 months, but we're going to look at this in 6 months and 9 months because we know they're going to be vigilant in 2 months. Well, it's been 3 years. They've survived stings. They've survived fraudulent stings. And here we are, and they're coming back for a second bite of the apple. Again, last case, in the Board of Health of Woburn, Judicial Court emphasized that a board must act in a fair, judicial, and reasonable manner. A board cannot arbitrarily re-examine and reverse its prior rulings, especially if the party at issue has remained in compliance. That's the law. It's before you. The cases are cited. Now, counsel gave argument before, and whoa, we have this. This is the law. No, it's you determined what the law was 3 years ago, last March. That's the law in the town of Barnstable. If you, at the time, Dr. Caniff said maybe we should pass a bylaw to oppose it. You haven't done that. If you did that, well, it's a different story. I'm not suggesting you do. I suggest you don't. But that, it was in your power, okay? So this particular action should not go forward because you do not have the authority to act under the law. Thank you. I'll take any questions you have.
Thank you, Dave. Any public comment on this one? One thing I just want to mention is, one thing I learned from the Concom is the state regulation is a minimum requirement. As far as the local regulations or ordinances goes, it has to be stringent than the state regulations. We cannot be less stringent than the state regulations. That's what the problem is in this case. And I just want to mention that there is another letter that our town attorney wrote in the letter, was dated April the 9th, and mentioned that on March 22nd, 2022, the Board of Health incorrectly applied the state statutes and regulations. MGL Chapter 270, Sections 28 and 105, CMR 665 prohibits the consumption of flavored tobaccos outside of a smoking bar, and I intended to reduce the appeal and availability of flavored tobacco products to youth. Youth exposure to flavored tobacco products is certainly not curtailed when flavored tobacco products are permitted to be purchased only partially consumed and then carried out by the consumer. As you are aware, pertinent to the state presumptions, where some local regulations or action contradicts state law takes precedence. The board did not have any discretion to allow a standard or guidelines for partial consumption on the licensed premises, where state law requires consumption only on the licensed premises. Therefore, the board's decision on March 22nd, 2022 is invalid. State presumptions aside, even if the board fails to enforce the 105 CMR 665.0.00, the State Commission of the Public Health is authorized to act to effect compliance pertinent to 105 CMR 665.055D1, which is likely their next steps.
May I address that, Mr. Lee?
Sure.
That's an opinion of an attorney who's licensed to practice law just like me, and I gave you a different opinion. So your board made a ruling on the state statute 3 years ago, and you're bound by it, legally bound by the ruling. Now, counsel, I was there. Counsel made that same argument 3 years ago. And this board, including yourself, voted, you're bound by your prior vote. You can't go and re-vote something because someone gives you an opinion by the attorney. The attorney is not the judge. In this particular case, you are. Had they gone to the Superior Court and appealed it to the Superior Court, a judge could have overruled you. But they chose not to appeal, so therefore your ruling is in effect. So you're not, before you last time, 3 years ago, was both the state statute and the ordinance. You made a ruling. This board ruled that C.B. Perkins could allow someone to come in, buy a flavored product, as long as they consumed at least one or partial of the product on site, they could remove with the balance. That's what you authorized. I'm telling you, you cannot overturn your decision unless there's some type of new set of facts that are here. There's not been a violation. The facts haven't changed. My client's business model is people come in, adults, and they can buy one pack, not 2, not 10, nothing. One pack or one vape. They have to consume a portion of it on site, and then they can leave with the balance. That was your decision. I suggest to you, you don't have the authority legally to overturn it. What counsel has wrote you was something that, well, you made a mistake back in 3 years ago. It was their job to appeal it. They did not do that. They did not appeal it. So whether or not they would have won in the Superior Court, I don't know. I'm not a judge. I'm not going to tell you whether they would have won or lost. I certainly would have presented my arguments. They would have presented theirs, and a judge would have rendered a decision. But because it hasn't changed, you can't do that. That's what I'm explaining to you.
Tom, man.
Thank you.
It's the law.
Don?
A couple of things. First of all, since Mr. Coletti wasn't here to hear the beginning of your remarks, and especially since I know I have probably been one of the most vocal about this, basically from the perspective of being a little bit more libertarian than many of my colleagues here. Never, I don't think, did any of us, although I wouldn't speak for all of us, but I don't think any of us ever implied that we thought that Mr. Coletti was illegally, unethically, or in any other way trying to set up stings. Clearly, he had somebody who came in and did something that he said he did not expect or think this person was going to do. We were not, Mr. Coletti is a man who is trying to do the job that he was hired by the Commonwealth or by the town, whichever, to do, and has been doing a pretty heroic job of it, even though I happen to disagree with where we are as far as that's concerned. And to impugn his character by implying that he was trying to set something up, I really think is totally aside from anything that any of us have ever tried to do.
Fair enough. I think I was suggesting it happened under his watch, and I think at the
It did
hearing-
happen under his watch, but that was not, and I also remember some of the comments that you made to the other side at the time, and they weren't exactly the greatest. Now, also, you've got doctors, dentists, engineers, PhDs, sitting on a board of health. We're not a judiciary body. Our attorney has come back and given us an opinion that we did not have an attorney, and I had actually, I think, reached out to the town attorney at the time and said, please help guide us, has given us an opinion that what we did wasn't something we could do. Seems to me that it's pretty reasonable for us to get an attorney who is advocating from our perspective what can be done next, and that we would generally take the advice of our attorney or of the town attorney, as we have in the past.
I mean, the one thing I will say, that the attorney did not review the argument that I made, that they argued what they should have argued back 3 years ago. What they didn't argue was...
Also, the case that that particular instance was clearly, I mean, that was the first time in the, I don't know how many years I've been on this board, but that was the first time in any of the cigarette cases that have been brought to us where it was obvious that somebody was trying to do something that was wrong.
Oh, Dr.
As
G,
opposed to simply going in and purchase
okay.
and see whether or not the vendor was actually following
Well,
the law.
the case I brought up about in 2023 was just an example of how my clients have been in compliance, and even when it doesn't actually go to the root of my argument. Maybe I shouldn't have been so aggressive with it, and I don't mean to offend anybody. And if I please accept my apology. With respect to my argument is that in 2022, that's the operative date, that the attorneys in their legal brief to you and the discussion on March 22nd didn't address the fact that you don't have the authority to overturn yourself. Now, whether or not they didn't think about that issue as to standing to come back again, that's not been addressed by your attorneys. Now, they just got their brief today. If they want to have a continuance, we come back again and they can brief it and we can exchange briefs, that's fine. I didn't have notice of the last meeting. And, and that was, quite frankly, as the British would say, is not necessarily cricket. But the issue here is that the issue of your ability to overturn yourself based on that case law, they don't have it. And that's what I'm arguing.
Well, and I would think that most of us would want an opinion from our attorney as to
Well, then
the validity of that
I certainly
argument,
would agree to
because
it.
none of us are attorneys.
I certainly would agree to a continuance on that, and I would hope that I can exchange briefs ahead of time and go from there. But this is an issue of do you have the standing to do it? And I suggest you don't.
Okay, thank you, Dave. Allison, do you want to chime in?
Allison Cogliano, Assistant Town Attorney. Nice to see you all. So I guess the question here is whether or not you have the ability to overturn, and I would suggest that that's not why we're here. We're here on a new violation, a new notice that was issued 2 months ago. And so we're not trying to retroactively enforce this violation. You made a decision a few years back. That's how they've been operating, right? But now my department has come in, reviewed the decision, and understood based on the states chiming in on things and a few of you that that operation is contrary to state law. And I am the author of the letter that Chairman Lee did read into the record, and I would say that we have a duty to follow state law. And again, the only way we can create regulations that are different from state law is if it's more stringent, not less stringent. So again, I would invite the representatives from the state that are here today to talk about any ongoing or new violations that we have based this notice on. And again, I think that would go towards the argument of we're talking about a new violation, we're talking about making a new decision, not so much retroactively saying you've been in violation for these 3 years, so we're going to retroactively, punish you, quote unquote. That's not why we're here. We're just talking about moving forward. If the board would prefer me look at the brief that David Lawler has given us today, I'm happy to do that as well, and we can continue it. But I do know that they came from Boston today, so let's give them an opportunity to at least answer any questions you have about that aspect of things. And then I'm happy to come back up if you have further legal questions. Okay?
Thank you, Allison. I just want to mention that Allison is mentioned is the order that issued by Tom McKeon on April the 2nd, 2025. That is the violation that we are looking at this point. So, Michelle?
Thanks very much. I need to clarify something. My name is Cheryl Sabara. I am the Executive Director and Senior Staff Attorney for the Massachusetts Association of Health Boards. I do not represent the Department of Public Health. I do not have clients. I provide legal education and technical assistance to the 351 boards of health in Massachusetts. I do work closely with the DPH attorneys on this, and I'd like to go back a little further in history. This whole exemption for smoking bars started when the legislature was looking at smoke-free workplace laws, which was a very, very long time ago. And at the time, the only smoking bars that there were cigar bars. And that's when, I don't have to describe what a cigar bar is, but it wasn't when you were purchasing a vaping product or a pack of cigarettes. The purpose behind the exemption was to exempt cigar bars. Since then, there have been flavored tobacco products that have come on the market in the form of cigarettes, vapes, and now oral nicotine pouches. And the legislature, in its wisdom, continues to exempt smoking bars, not cigar bars, but smoking bars. So that's how we ended up where we are. Now, the state law, and I'm sure my brother counsel understands that a state law is, when you're looking at the hierarchy of laws, you've got the federal law, then you have the state law, and then you have the local law. That's what we're taught in law school. Then you look at whether the state law preempts you from doing something, or whether you, as a local municipality, have the right to further regulate something. So the state statute that we're talking about exempts it states that this subsection shall not apply to the sale or distribution by a smoking bar of flavored tobacco products or tobacco product flavor enhancers for on-site consumption. Then what the legislature did was they ordered the Department of Public Health to create regulations in order to enforce this law. So here we have the state statute, and then we have the state regulation. And that regulation also exempts smoking bars, saying, except for a smoking bar for on-site consumption only. So they clarified, if you thought that it was not clear in the statute, the Department of Public Health's Public Health Council clarified that in the regulations. Now, the argument that you can't overturn your own decision sort of flies in the face of the liability protection that municipal employees, which includes appointed and elected municipal boards, has. You were acting in your discretionary function when you actually dismissed the cases. You didn't find any liability because you were unhappy with the behavior you saw in those tapes, which I don't blame you. That is a lesson learned that we've brought back to all of our programs. But that's how you remedy something. You're not stuck with a decision because you ruled one way on one time 2 years ago. You have the right to exercise your discretionary function. So I would contend in this case, you have the absolute legal authority to listen to what your town council has suggested to you. And I would also say that I don't have any standing to have filed an appeal in the Superior Court because I don't represent the town of Barnstable. That's your town council's position, but you didn't have an obligation to do that either. So, and I would also suggest that when Barnstable became a member of the Cape Cod Tobacco Control Collaborative, they agreed to ensure that they are complying with laws or regulations and fairly and consistently enforce them if they're found to be in violation of a state or a local law. So there's no wiggle room here, but there's no liability for the decision that you made because you exercised your discretionary function when you decided that you had the ability to weaken the state law by requiring one cigarette has to get smoked and then you can take the right out. And Dr. G, we've been going back and forth on this. I mean, I've said I understand you disagree with this law and you think it reminds you of East Germany when you're in Massachusetts. And I've heard you say that many, many times, but it doesn't change the fact that it's a state law.
And I recognize that. And I understand. So what you're saying, though, is that if we make a decision in the absence of counsel, and then with the benefit of counsel, come to understand that the decision that we made really wasn't within our purview to make.
Correct.
There is no reason why we can't back up and say, okay, we need to address this new case.
There is no liability
that has-
for complying with the law, even if you didn't before because you were not advised as such by your attorney. Thanks.
The other things too on that agreement, this morning I saw the agreement that was signed by Paul at that time. It was the chairman, it's by Paul, at that time, it's 2018, it's sent to all of you. So the only thing that we are doing here is not looking back and a couple years ago in terms of that. We are looking at this cease and desist order issued by Tom on April the 2nd, 2025. This is what we're looking at this point. So
So what sparked this on April 22nd? Was there another, did Mr. Coletti have another, I mean, how did this come to be raised? Please.
Go ahead.
I got a call from the director of the Massachusetts Cessation and Prevention Program, and she informed me that they had been receiving complaints from, not just one complaint, but complaints from other individuals in Barnstable who were complaining that this store was allowing people to purchase flavored tobacco products and walk out the door. So she called me and asked me what I thought they should do at this point, and I said, I think I should reach out to town council and let town council know what is up. So we had a meeting with town council, a Zoom meeting, and we discussed it, and hence that's why we're here.
So one of the things that we've learned over time is that the ever-escalating fines that get attached to this, we don't really have any discretion about.
No.
If they were in fact acting on what they thought was what we had told them they could do, do they really need to be fined for doing what the Board of Health said they could do?
I would defer that to town council. If it were up to me, I would say, let's just move forward. We're about compliance, not about punishment.
Okay.
Let's just move forward and comply with the law moving forward. But that's just my personal opinion.
Thank you.
Thank you.
May I?
Sure.
So, and again, I have no reason to dispute what she said. She got a phone call from a competitor that was addressed, okay? There's no evidence that they didn't comply with this board's order no evidence that they didn't do that. And counsel talked about, she didn't reference any case law addressing my issue, okay? I represent doctors. You guys, in the most part, I'm not trying to suck up to you, are smarter than lawyers. Read the cases. They're very clear. You don't have the authority. You had the authority to interpret the statute 3 years ago. You did so. They didn't appeal. Now, the town, Mr. McKeon referenced the attorneys. This thing's public record. The Tobacco Control Board could have appealed, or the town of Barnstable could have appealed. They didn't do it. That's the law. You're talking about following the law. I'm providing you the law in a very simple basis. Not that the opinion of counsel is that it's a new violation. It's not a new violation. It's in complete compliance with this board's order, and there's nothing before you. Again, you have the authority to change the rules if you want to, but I suggest you don't. We're in complete compliance with this board's decision. It's not up to the tobacco board. It's a special interest group. Obviously, they're trying to promote good things, whatever they are, and certainly what they believe to be. But they're not. They don't have the. As she indicated herself, she doesn't have the authority. What the authority simply was, the cases are right in front of you. You can't overturn yourself based upon no new evidence. The only evidence you have is they continue to comply with your order. That's it. Nothing. And I suggest you can't do it. And if you need it, if it wants to be rebriefed or whatever, but it's just, you are up there, you are doctors, but your decisions, you are a quasi-judicial board. You are the judges, and you make up your own minds based upon the evidence provided to you. Now, you listen to staff, you can listen to your lawyers, you can listen to me, but based upon, and then you make up your mind as to what the law is. And I suggest to you, I'm the only one who has provided you actual case law, and in that, and with respect to the historic nature of this particular statute, I actually included a letter at the very end by Mr. Demetrius Atasalis, who was the state rep when all things happened, and he actually disagrees with some of the legislative intent. So, and there's a letter. He was on, I think, in 2012, but it was involved. He goes into his history. I'm not sure. It's certainly not binding or anything, but it's more of an explanation. But that's the situation. So I think that something of this serious that's been going on for 3 years deserves further, keep the public hearing open, and I think that you should review it in greater detail in these particular arguments. Thank you.
Allison?
I'm just going to, David and I can argue in court. But so just based off of what you all just heard, I would suggest that boards and commissions, you change members all the time, right? We've got different, and this is 3 years, and I don't know what the makeup was at that time because I was not here, but either way, if you all were bound by the decisions of former commissions, former boards, there would be no purpose. We would have no purpose, right? Because that would be the precedent that is set and that is going to be followed till the end of time until the law changes, right? So the suggestion that a decision that you made 3 years ago, you don't have the authority to overturn, I understand. That's not what we're trying to do, again, as I said previously. The ongoing violation of the state law, regardless of what the Board of Health 3 years ago stated that this company or this business could do, how they could operate, it's still a fact that it's in violation of state law. And again, with the principles of state preemption, we have a duty to follow state law. And we did not do that. And again, there's the ongoing violation of that state law. Therefore, you have the ability to make a new determination. And this time, I'm able to give you my legal opinion, right? So it's your vote. That's my take on it. Again, case law aside, I could find plenty of case law about state preemption. It's a very, very, it's a big deal. It's so, and I'll end with saying that these are the DPH regs. These are the regs that they created. And we have people from DPH here to tell us what those regs mean. So in terms of legislative intent, whether or not there's a disagreement or not, these are the individuals that are enforcing those regulations at the end of the day. And so if you as a board do not sustain the notice, the cease and desist, we have a state entity that's going to do it, I assume. And so I'll leave you with that. And I think, again, David and I, we have plenty of opportunities to argue against each other in court, so we don't have to go back and forth. But if you have any other questions.
Thank you, Allison. Like I said, we are looking at the order issued on April the 2nd, 2025. That's what we're trying to do here. We are not trying to look back 2 years ago in terms of our previous determinations. From, I have been sitting on many boards and understand from time to time, we also change our interpretations of the law. But we cannot go back and change the state regulations per se. I mean, we can try to change the local ordinances, but not the state regulation. We don't have the authority to do that. But that's my comments.
Are we aware, are there any other smoking bars in the state of Massachusetts that allow their customers to take flavored tobacco products off the premises after they're partially consumed? Or is CB Perkins the only one?
They're the only one. There are only, I believe it's 24 smoking
Cheryl, do you want to speak on the mic? I just want to make sure on the because it's recorded.
No, and I was going to bring this up. There are 27. Half of them are in Worcester. The rest are in Alston, Everett, Agawam. No, there are none. And I would just respectfully suggest that if every Board of Health was able to interpret a state law the way they want to, then what's the purpose of a state law? The plain meaning of the words in the statute, which is what you're supposed to look at first, we learned that in law school too, is when it says for on-site consumption only, that's what it means.
Thank you. Any more questions? Can I ask Christine to do a motion?
Yes, motion to sustain the April 2nd, 2025 order to cease and desist issued to CB Perkins Cigar Lounge and Bar.
Second. All in favor?
Aye.
So the one thing I just want to mention, the
Just want to thank you for your time. I know you guys are
are.
volunteers. Thank you very much.
Thank you.
Thank you. The effect of the order to cease and desist voids the original decisions by the Board of Health on these issues. Thank you. The second one is tobacco violations. Mohammed Shafiq, owner, representing Billow Corporation, Willow Package Store, 700 Yarmouth Road, Hyannis, map parcel 345-010-003. On May 10, 2025, cigar were sold to a minor under the age of 21 of employee. Let me go to Bob first, and then I'll go to you. Thank you, Allison, and thank you, Cheryl, and thanks. Make sure your mic is on.
Yeah. Okay, thank you, Mr. Chair, members of the board. Here to attest that on May 10th at 5:57 p.m., a 19-year-old male was successful in purchasing a Black and Mild cigarillo at Willow Package. Was not asked for an ID. It was a male, a young adult clerk at the time. Paid $1.05.
Thank you, Bob. Do you want to come up?
Good evening. My name is Shakil Farouk, and I'm on a Willow Package.
Okay.
And
What was your name again?
Shakil Farouk. Shakil Farouk.
Are you Mohammed Shafiq?
He's my brother.
Oh, it's your
I don't
brother.
know. Yeah.
Make sure you sign the sheets, because otherwise it's going to be difficult to try to spell it.
No, I'm the owner. I don't know why they put my brother name on that business.
Oh, okay.
Okay.
So that's I worry about it, because last time, hearing 3 years ago, it was my name, and this time they my brother name.
Okay.
So I still sign?
Yeah, make sure you sign it, because for the record, on the minutes and stuff like that, we want to make sure that your name is properly spelled. It's not like my name. My name is easy. L-E-E. Done. Huh?
Yes, since the last violation 3 years
Is your
ago.
mic on?
Yes. Since the last violation, we buy a new machine for ID check every time, and every time we call our employees, please check ID. Sometimes they leave, sometimes they give me a hard time, and because this time my 3 children one go to Boston, one go to in Albany in RPI, and my daughter is high school.
I'm sorry, can you talk a little louder? I
So, I mean,
can't hear you.
my 3 children, I say, because one go to Boston and one go to in Albany in RPI, and my daughter is high school. Sometimes you hire an employee and keep saying that, please check your ID, please check ID, and new machine over there since 2 years now, and I don't know what happened how they happen, and I mean, we always call that to, come and go, to pick that children. Sometimes they give a hard time. Oh, you got to work yourself, hire other employee. And, I always said that, please check ID, check your ID, check ID. I mean, I have no idea how they happen.
But in this case, it happens, right?
Yes.
Okay.
I mean, we have in 2 weeks, I caught these IDs for, if you want. I mean, I was there since I get the letter, and they caught like 5 people, 5 children to fake IDs with the come buying anything like a liquor or cigar, because both 21 now, and they put them there. They said, oh, fake, and they keep it. And since the violation, I mean, if you want me to leave it there?
No, it's okay.
I mean, I don't do that.
No, I don't. They make good decorations on the wall.
They all I mean, they come with the IDs. I mean, sometimes the lines there, I'm working in the cooler or there, they give us sometimes the hard time. They said, they yell on me and give abuse and everything. I said, don't worry. You say, go next door, go somewhere else. I can't sell that. That's only, they do that.
So, Bob, for this offense, do we have to put a fine on or what?
Yeah, which offense is this, Tom?
It's the first in 3 years.
First in 3 years, yes. So, yes, it would be a mandatory $1,000 fine and a suspension of
1 day?
1 day, yeah.
Okay. A lot of times.
You know, the law says, as I'm reading it here, within a 36-month period, the first offense is 1,000. The second offense is 2,000.
Right, and this is the first offense, Tom? First offense, Dr. Caniff.
I thought it was the second. It said on January 9th, 2023.
Okay, then, so it is a second.
Well, that's what I'm reading. Everybody else must be reading the same thing.
Yeah, there was a question of ownership in the time period, but you're saying it's the same owner for 3 years?
Yes, that's me.
Okay.
Yeah, so then you're correct, Dr. Caniff. Second offense would be mandatory $2,000 fine and the suspension.
Is it 1 day or 2 days?
It's the board's discretion between 1 and 14, I believe, for the second offense.
I think in the past, I think we took the Christmas Day as the day that you are suspended for selling cigarettes.
I mean, I work hard to call everybody, so every time I said that, please check your ID, please check everybody ID, check everybody ID. I mean, I just, since they have got 5, 6 IDs for I'm very tough because I have 3 children, more than, I think I'm more tough than everybody I try. Only I can try to imply to, sit there for every time call.
No, we understand.
Yeah.
We understand that.
I mean,
I don't think we're questioning that at all. This is
Absolutely.
this is
The law.
this is the law. It's not a particularly pro-business law, but it is the law.
Yes.
And it sounds like you're doing actually an admirable job of keeping of doing what you can to prevent the sales. What we don't have, and what I think hopefully you were here for the prior, what we don't have is a whole lot of discretion in what we can do. Because it's the second offense within a 3-year period of time, the fine is dictated to be a $2,000 fine. The only discretion that we've managed to find is the suspension, and that's why we've ended up saying the suspension is a 1-day suspension on Christmas Day, because, to be honest, we've asked the business owners, what is your least busy day for selling cigarettes, so that at least we could exercise a little discretion in there. But this isn't to imply that you haven't done everything you can. It's to say that, unfortunately, any of us who at one point or another have run a business and have hired teenagers or younger people have found that they make mistakes, and people my age make mistakes too. And unfortunately, that mistake is now your problem, and we don't have a whole lot of discretion as to how to deal with that problem. But it does sound like you're doing a great job of pulling as many of the fake IDs. I've got a couple at home from my daughters that I found that I could add to Bob's.
Yeah, with my own son's the pile too.
If Christmas Day is not good for you, you can
Yeah,
make a
Christmas Day is
suggestion.
good. Christmas Day is
Good.
good. Yeah, thank you.
Yep. So could I have a motion to leave the fine of $2,000 and 1-day suspension on Christmas?
So moved.
Second?
All in favor?
Aye.
Aye. Thank you.
Thank you, sir. Thank you.
Thank you, Bob.
Thank you. Mr. Chair, if I may just add one anecdotal note on that. So this was a Saturday evening, and actually I picked up, he's a baby-faced 19-year-old young man that I was taking to Yarmouth. That's where we were headed to do all of the stores there. And we come off at the old exit 7 and just hit those quick little stores right along the way there because they hadn't been checked yet this year. And then we went to Cappy's and Absolute Wine and Spirits. So 5 stores. Out of those, 2 of them sold, and 0 in Yarmouth. So I was very surprised. And it drives home a point, just that they always have to be vigilant, even on weekends. We're out there 7 days a week.
Right.
And so I know that the owners can't be there every day, every hour. Some are, some are not, but it's...
So do you work Christmas Day?
You never know. Tom thought I worked on New Year's Eve one time. I remember that, but that wasn't the case. No, we're not trying to, as you know, we don't try to deceive anybody. But no, Christmas Day we do not work typically.
Thank you.
All right, thank you.
Thank you,
Bye-bye.
Bob.
All right, thank you.
The next item on the agenda is the Type 10 John O'Day representing Lena and Edward Lesetsky's 129 Hayes Road, Centerville, map parcel 210-095, phase 1 of the CWMP failed septic system variances requested from 310 CMR 15.305 State Environmental Code Title 5 and from section 360-44 deadlines to repair failed septic system, Town of Barnstable Code. John?
Good afternoon, John O'Day from Sullivan Engineering Consulting. We've been here quite a bit on this property. For better or worse,
I better recuse myself. Although it's done.
It's done.
it's done.
So I guess I'm all right.
The good news is that these tight tanks, although we were granted relief to the fall, are being installed. One of the tanks was actually put in today, and the owners have opted to increase the capacity so that there would be less pumping frequency. So where we were allowed to have a 1,000 stay for the summer, we're actually, the plan had proposed 2,000 gallons. And actually, since this plan was prepared, the contractors, the 2,000s were not available in monolithic, so we had proposed to seal the tanks. Contractors found that for some reason 2,500 gallons are available in one piece, so we're doing 2,500 gallons instead of 1,000. But that additional size didn't need additional relief to the property lines, and so that's why we're here today. But as I said, we were able to get an emergency order to begin the construction, and we should be done by tomorrow.
Thank you.
Yeah, the first tank is in.
What?
They put the first tank in today,
Right, right.
and, it's gonna be all right.
Yeah, yeah. I mean, bigger is better in terms of the capacity, right, for the septic tank, for the tight tank, not septic tank.
Takes longer to pump, that's all.
Right. Could I have a motion to approve the variance request?
So moved.
Second?
All in favor?
Aye.
Aye.
Thank
Thank
you.
you.
Thank you.
You want any plans?
Thank you for working with us on this.
No, all permitted, thank you.
The next item is the septic variances. Dan Ojala, PE Down Cape Engineering, representing owner. J. Nicholas / S. Vandermoor, 49 Lakeside Drive East, Centerville, map parcel 252-098, requesting reductions in minimum setback distances from soil absorptions to the BVW and pump chamber to the BVW as required from Town of Barnstable's Code 360-1 under 310 CMR 15.221 State Environmental Code variance for increase in cover over the pump chamber, and 310 CMR 15.255 variance requesting a 1 foot from required 5 foot removal of unsuitable or impermeable soil beyond the outer perimeter of the SAS, 5 feet to 4 feet.
Mr. Chairman?
Yeah.
I just want to disclose Dr. Vandermeer was on staff at Cape Cod Hospital. He was one of the folks that I worked with when I was there.
Okay, thanks. Dan? Make sure
Good
mic
evening.
is on.
Yep.
Yep.
Dan Ojala from Down Cape Engineering. This is a variance as stated for under maximum feasible compliance, whereas the CMR allows you to do the best you can with what you have. It's a tight site, but by pumping it, we're able to get the full 5-foot separation to groundwater. And as we know from the DeFeo and weight study of Title V, that's more important than the horizontal because you get that good vertical separation to groundwater, get rid of the pathogens prior to it entering the groundwater where it could then travel. It doesn't meet any state the variances to the wetland. We're full 71 feet away. We did have to put a pump chamber in to lift up, and the pump chamber is slightly deeper than needed, but again, that's a sealed unit, and it's going to a leaching, which is the more critical component to be close to grade because it breathes better. That way the leaching can stay aerobic and it tends to last longer. So as you went through, there's a list of variances. SAS to foundation, we're going down to 15.8. But that's pretty reasonable. They're routinely granted, and the flow of effluent tends to be pretty much straight down. There is a liner which would mitigate any chance if we did have a breakout that it would not enter the basement. Reduction setback water line to SAS 10 to 3, but again, we've got that liner on the outside. There's a note 22 where we're going to sleeve the water line within 10 feet, and that's generally fine. You can cross, and again, we have some clearance. And then those are under maximum feasible compliance. Again, we meet the setback to wetlands, which state code, but under your code, that would be SAS to BVW from 100 to 71, again, not too bad. Pump chamber is 69 instead of 100, but again, that's a sealed unit, so we don't usually concern ourselves too much with those variances. And then there is requested 1.23 feet deeper over the pump chamber. Again, that's no harm, no foul, because we'll have a cover up to grade, and that's a sealed unit anyway. And then 15.2555, 1 foot's requested from the 5-foot removal. There's just not quite enough room to do the full, but we'll do 4 feet around. And again, it's a quite sandy soils, no real problems in this area. The perk test showed medium coarse sand all the way to down to the lake level, so no issues there. It's pretty straightforward, no new bedrooms, doing the best we can with what we have, and perhaps a sewer will come by sooner than later. But until then, we've got a pretty good situation. I'd be glad to answer any questions.
Thank you, Dan. Any public comment on this one? None? Staff?
Staff has no objections. However, a request is made to request a three-bedroom deed restriction.
Sure, if there's language that it would be lifted if the sewer comes through, or is that implied?
It would be lifted, removed, right?
Right.
You could put that in language.
The reason for it is gone, yeah. Yeah, I think would be fine with that. I don't think that would be any chance of increasing flow on this site, given this constraint, so I think that's reasonable.
Any other board member questions?
How often do they install those table filters?
They actually require them now, so we're doing them on all pump chamber systems. And then cleaning them, you just basically take a garden hose and rinse it back into the upstream part of the tank. So, I think they recommend every couple of months, but certainly if it starts backing up as needed.
This house is, in the sewer, going to be stored, so I think it's a commendable thing that he's putting in the system.
Right.
Now,
Dan, I got a couple questions for you. Number one, do you have a basement where your house is facing the leaching field?
Yes, there is a basement over on that side, but again, it's a full 16 feet with a liner.
So you have a liner on the other side, on the side of that?
Yeah, on the outside of the removal, that kind of a perforated line represents a 40 mil liner.
Okay.
So that'll help protect the basement.
Okay. And then the second question is a minor question, because you have your water pipe just outside of your digging in terms of your SAS there. You should sleeve it, at least. Sleeve it?
Yes.
Sleeve the water pipe?
Yes, yeah, we picked that up, I think it was note 22.
Yep.
I'm sorry, note 22, sleeve water line anywhere it's within 10 feet of the septic component. So we did pick that up, that's on the plan.
Okay.
Do you need a note about the liner? Does the installer know what the squiggly line is supposed to mean?
So, well, it is, yeah, that's 15 and 16, it's called out, those notes. And 16 is 90 feet of 40 mil liner,
Okay,
4 foot off the
that's
SAS.
covered.
Yep.
Yeah, so
And
both are
even
covered.
Yep.
Top and bottom elevations even, so we did a good job with that one.
So the reason for the deed restriction is because of the three bedrooms plus the loft? I believe that was the issue.
Yeah, it's denish, loftish thing, yeah. But let's definitely make sure that it's not used as a bedroom. That would be safe.
Okay.
Yeah. It's a three-bedroom design existing, so we didn't dare go up from that.
Could I have a motion to approve the variance request, plus you need a 3 bedrooms deed restriction?
Motion to approve.
All in favor?
Aye.
Thank you, Dan.
Thank you very much.
The next one is Dan Ojala, too. Is Don Cape Engineering representing owner JTD Trust, Jacob DeWitt TTE 692 Scuttling Avenue, Hyannis, map parcel 2X7-004, requesting variance under 310 CMR 15.2231B, State Environmental Code, use of a single compartment tank for existing dwelling, and proposed ADU effluent filter proposed in the outlet T of the existing tank. The existing system installed in 2019. Dan?
Good afternoon, Chairman Lee, members of the Board of Health. Again, for the record, Dan Ojala, I'm a civil engineer and a land surveyor with Down Cape Engineering in Yarmouthport, and helping Jake Dewey out with an ADU on the lot. It had recently been upgraded, the septic on the lot, and it's got sufficient bedrooms. And on behalf of Jake, we're requesting a variance to use the good-sized existing tank that's there. It's a single compartment, but technically under Title V, when you have an ADU or a second kitchen, they do like to see a multiple compartment tank. And due to the relatively small size of the lot, the lack of access, and also cost considerations, we're trying to provide some affordable housing here, or, de facto affordable, that we could use that existing tank. It was kind of a unique setup where there wasn't a lot of room, so they split the leaching with a splitter D-box into two, and there's just really not room to put in. And to get back there and put in a bigger dual compartment tank would be a real hardship financially. It's 5 bedrooms existing. It's only in 2019. What we thought we would do, and this board has looked somewhat favorably on the past, is an effluent filter, a Zabel filter, in the outlet T of the tank, which would provide, similar solids removal to a multi-compartment tank or 2 tanks in series. It's not really an environmental concern, whereas there's nitrogen or anything like that, but more of a leaching field longevity issue. And we feel the effluent filter would address that in a similar manner so that you could grant the variance without degrading from the intent of the rules. Again, the existing system was recently installed, and there's no increase in the number of bedrooms. And for those reasons, would respectfully ask you to approve the variance. There's some floor plans for the ADU, and it's explained how we're going to eliminate 1 bedroom. There's currently a bedroom in the front. It's going to be an open hall and office, and in that manner, we'll be able to get the bedroom in the ADU, the garage ADU. So I think that works well. If there's any questions, I'd be glad to answer them, and we sure would appreciate your consideration on this. I think it's a reasonable request. Glad to answer any questions.
Thank you, Dan. Any public comment on this one? Seeing none, staff?
I just wanted to let the board know that this is the first request for a variance of this nature, first variance request of this nature for ADUs. The state recently came down with a requirement for a double compartment tank when you have a house and an ADU. So this would be your first variance to consider. The state did provide information. You might have a copy today of the email, which allows you to grant a variance if number one, they can provide information about manifest injustice, and number two, provide information about providing an effluent filter. And I heard part 2, but I haven't heard part 1 of that here today. And my other concern about effluent filter is it's fine, but it has to be maintained. You have to remove that and hose it off every 6 months or so. So anytime you have these types of variance requests, I suggest you question who's going to do that, how are we going to ensure that's done so it doesn't cause a backup into the house of sewage. Thank you. That's all I have.
Thank you, Tom. Dan, can you address those 2 questions?
Yes, so we can have our regular septic pumper do that. If you'd like a condition of 6 month by cleaning, I think we could accommodate that. And it's always smart to, pump a little bit more frequently when you've got more flow. So if you want it pumped every 2 years, that would take care of a couple of those visits, and then in between, that's not too much hassle. We'll make sure we put a nice cover to grade H20 so that it's safe from kids but easy to pop off and clean so that it actually does get done. I think that's reasonable. Again, with the cost of construction, and if you look at, this is a very unique site, and if you look at, it's got a split leaching field, it's a paved driveway, it's very tight constraints, there's a panhandle on both sides, very, very thin access. So I think it has, some unique site features which, any plain Joe site just wouldn't have. It's almost impossible to get behind this with the tractor to put a new tank in. And there's not enough pitch to come out and then back, so they'd have to redo the brand-new leaching field. So I think it would be manifestly unjust to require, a tank in this case where there is a solution that we're willing to accommodate with an effluent filter, rather than really discombobulate this particularly tight site. For those reasons, we do think that financially it's a real hardship to have to install that tank, and it would be manifestly unjust. So would appreciate your consideration of that. Jake is a good member of the community, does a lot for the town, and will help provide, again, low-cost housing. So I think until the sewer comes, this is a good solution.
I just want to clarify, I'm not asking for you to add more cost by hiring somebody. If the homeowner is able to live there, and I'm not sure if that's the answer.
Yeah,
If the
that would probably
homeowner's-
be easier, either him or a handyman or someone, yeah, fair enough. That's a fair point, because if we have to have it under contract, it would be more expensive. But to have the homeowner at a minimum, or just cause it to be done every 6 months, would be probably a better condition.
Is your manhole cover easily accessible?
It will be by the time we're done. It's the cover was within 6 inches of grade, but we'll bring it to grade. That's important. I think it's buried 6 inches now, but we're going to put a cover right to grade on it.
Yeah, you should bring it up to grade, because otherwise it's going to not doing it if you bury that cover.
Yeah, and if you want to put a condition on it, I think that would be very smart, because out of sight is out of mind, so, yeah.
Any other question from the board member?
Some other things, this house is not on the list to ever be sold.
Down by the water there, the Kennedy area, yeah.
It has 5 bedrooms now.
Is your mic on?
No. It has 5 bedrooms now, and they intend to take one. If you look at the map, it says an office to patio, and convert that bedroom to the other, to go to the garage or whatever it is. And the size of the lot is just a little bit more than a quarter acre, so it's a little bit more than 10,000 square feet. It's a very small lot. And to have 5 or 6 bedrooms is, I think, some consideration where it's never going to be sewered. And also, I mean, I think it's not going to be, I don't believe it's owner occupied. So anyways, that's my concern, my thought, my input. I mean, if we approve one, we're gonna have to approve 1 million of them.
On the
Through the
setup-
chair, I could comment if you.
On the setup of the ADU, depending what it is. If the house, in this case, the house already has 5 bedrooms, they are the range of the number of bedrooms. You're not increasing the flow. That would be that would be.
Right, I know, but I mean, it's still an increase.
Right.
Through the chair, I would add too, though, that we're not in a zone of contribution, and we're also, if you look at the locus map, it's the open water, the sound, so you're not in an embayment area, one of those nitrogen-sensitive areas, so.
I brought the map too, in case anybody wants to look at it. It's
Yeah.
not in any
Yeah,
nitrogen-sensitive areas, correct?
Yeah, and in that manner, that's probably the reason it is not teed up to be sewered, but, so it's really just a longevity issue, and it's already at the 5 bedrooms. We're not increasing the footprint, it's over the garage. And I think I would cite, given the unique situations of a very small lot, an existing garage that can easily be converted into ADU. The ADUs are as of right now, but as long as they meet Title V. Could it be done to do a second compartment? It could, but it would be very expensive. And in this particular case, if you've got a bigger site and someone wants to do an ADU, have them put the second tank all day long. It's probably a little bit better solution, but it's certainly short-term. It's just on this particular site, it's so tight that it's hard to do. And I think that someone would also look at your 6-month requirement on the cleaning and say, maybe I'll just put in that other tank, so I only have to deal with it every few years. That is a downside to having the effluent filter, but I think it's, in this particular case, it makes sense, it's unique, it's an odd shape, it's small, and with a brand-new septic that is not conducive to adding on to, and we're agreeing to a 6-month clean out of the Zabel.
The owner does have about 8 or 9 other properties, and
Yeah, he's a good landlord.
Any more questions from the board member? Could I approve this variance request with the following conditions? One, raise your manhole cover to gray for your effluent filter, and have that effluent filter cleaned out every 6 months, and pump the septic tanks once every 2 years.
Say the second part again.
The filter?
Raise the manhole cover to grade.
Yeah.
What was number 2?
Clean the filter, effluent filter,
Every 6 months.
every 6 months. And pump the septic tank once every 2 years.
Pump septic tank once every 2 years.
Second?
All in favor?
Aye.
Approve? Oppose? One.
One oppose?
Thank you, Dan.
Appreciate your careful consideration. Thank you.
The last septic variance is Chuck Rowland, Cape and Island Engineering, representing owner, Howard Kovacs, 265 Seaview Avenue, Austinville, map parcel 138-020, requesting a reduction in minimum setbacks distances within 100 foot from coastal banks as required from the town of Barnstable Code 360-1, locations of the components with respect to water bodies and variance under 310 CMR 15.211 state environmental code minimum setbacks for proposed swimming pool within 20 feet of existing leach field. Hi, Chuck.
Good evening, Chuck Rowland, Cape and Islands Engineering.
Make sure your mic is on. Okay.
I think so. I'm representing you tonight for the owners of 162 Seaview Avenue in Osterville. Presently, the site is developed with a single-family dwelling. We're proposing an addition, pool cabana, as well as some other accessories. We're putting in a garage, as well as new walkways, patios. I will be in front of your other board, Chairman Lee. And so I'll get into the conservation stuff for that board.
Next week.
Yes. For this, I'm coming in front of you for the proposed pool and the setback to the proposed pool. So the pool is considered a foundation, and I don't remember which one it is, but the reduction in separation would be considered a counter variance. But obviously, I'm in front of this board, so hopefully you guys will approve that. So typically, the separation to the existing leach field to a proposed pool is 20 feet, and we actually have it as 15.2. It's a fairly standard variance that you can get approved just at the board, I mean at the counter. So typically, you don't have to go to the board for that type of approval. And then the second variance is the proposed tank from the top of Coastal Bank to the proposed tank is 92 feet. You have a town regulation that says it has to be 100 feet. Obviously, if I go to 100 feet, I would have to be requesting a distance to a property line. The reason why we need a second tank is because with the new clarification documents from the state, the proposed pool cabana meets the definition of an ADU. I'm not going to speak as to whether my client will be renting it out as an ADU. Technically, they could, but let's be honest, it's probably not going to happen. So we've proposed a 1,000-gallon septic tank. I believe that with this septic tank, we are increasing the amount of treatment going into the leach field. And so I believe it's a fairly minimal variance request that we're asking. So with that, I'm happy to take any questions.
Any public comment on this one? None? Staff?
Before I offer the staff, I have a question. By constructing this addition, are you eliminating a reserve area for the septic system? I don't see a reserve area.
I'm happy to work on putting in a reserve area. Usually the reserve area is for when we're talking about work we're doing to a leach field. Obviously, we're not touching the leach field on this project. But
Did you say usually, would you say usually the reserve area is what?
is when I'm working on a project with it, we're working
Oh,
on
I
a
see.
leach field. Obviously, we're not I don't have the regs in front of me, the way I read it is, my understanding is that if we're working on altering a leach field, proposing a leach field, so on and so forth, that's when I would have to show a reserve. If you would like, I can.
Yeah, well, I've addressed this with staff in the past. If the building is, if they're adding on to a building, it's taking up more of the property, so you're losing reserve area, there's a concern there to provide a reserve area. That's just my opinion. I don't know how the board wants to address that. Other than that, the staff has no objections to these setback variance requests. That's all I have. Thank you.
I don't think it's a requirement to show the reserve area, but that's neither here nor there. The other thing is that when the leach field fails, usually, I know that I don't really know why the state has the regulation for a reserve area for a proposed parcel, because when the leach field fails, you rip out the old leach field and you rip out the material that has failed, especially in an area like this with very clean sand, and I can tell you that it's very clean sand. So you just rip out the old leach field and you replace it. You rip out any old barrier that that has failed the system. So I mean, hydraulically, you rip it out, put in fresh sand, and you put it back in the same place. But with that said, I'm happy to show a reserve area on the plan if you would like.
Maybe I'm just speaking from my experience. When we designing the Title V leaching systems, we always trying to show the reserve areas as required from the DEP. The reason that you're trying to show that is to make sure you have the reserve area in your lot to take it. Yes, the homeowner can replace the whole leaching field and put a new one in, but you are not providing the area required under the DEP regulation as far as the Title V goes as an option. Because by the time you fail, you want to go as quick as possible to put this leaching field in. When you have a reserve area, you can just go there and build it and you're done. You come back and then your system is up and running. You don't have to replace all the failed septic system. I mean, the leaching field area. It's much a bigger job.
Yeah. So we're not proposing to a leach field at this time.
But you have it. But you're showing the leaching field in here, right?
Yeah, we're showing the existing leaching field, yes.
But I think I agree with the staff. You should try to show your reserve area.
I'm happy to show a reserve area.
Yeah, that's all.
It's not going to meet setbacks, the 100 feet.
That's fine.
But
you should try to show the reserve area. I mean, even if you have to take some variance, I mean, the variance request for that.
I'm happy to show that.
Yeah.
Is that something you would be able to approve, subject to the submission of a revised plan showing a reserve area?
Yeah.
Yeah, we're okay with that. We don't want to hold up the process.
Right. Right.
Yeah, just, can you give me a general idea of what the setbacks would be for your letter, though, for the reserve area? Would it be the same, about the same as these setbacks?
I'd stuff it underneath the driveway on the northeast corner here.
Okay.
Yeah.
I mean, if you allow the letter, we can wait for the
No,
plans
waiting for the revised plan.
before we do the write the letter.
Yeah,
Yes,
yeah.
we'll do it.
So that way you know where your reserve is and write the approval letter for that.
I'd likely probably split it into two different areas, like a 50% reserve type things.
Yep,
Yeah, that's fine. Yeah.
That's fine.
Can you just take a quick moment and just educate me and anyone else who's not familiar with the reserve area? And we haven't talked about that before.
The reserve area basically is assuming that, just like in here in this design.
Yep.
You see your leaching field in there, right?
Yes.
But there's no backup, 100% backup that you're looking for. That's why he's trying to put it under the driveway. But then when you put it under the driveway, you need a vent for the leaching system as well. So that's why you make sure that you have enough space on your lot to do the reserve area.
And that's typically for a new construction.
Right.
So obviously this is not new construction. This house has been here for like 100 years or something like
Right,
that.
right.
So I'm not even touching the existing leach field. And so, but we're happy to work with you guys in showing something like that. But
I'm more on the conservative side of the engineer.
and the entire parcel is within 100 feet of the coastal bank, and so the reserve won't meet like your bylaws, but I'm happy to show.
I don't know where the reserve area is on the original plan, whether it's in the area of the addition or somewhere else.
Right.
Because it's not shown on this plan, but
Right.
there would have been one for the original plan.
Right. But now you don't know where because they expand the house lot on the plan right now. That's why I'm asking you should show it so that you know where they are.
Happy to do that.
Could I have a motion to approve the variance request subject to the receipt of a revised plan showing the reserve area?
Second?
All in favor?
Aye.
Thank you
Chuck.
very much.
See you next week.
Chuck, you want plans back?
No, I have to revise them. I can't use them. Thank you.
Thank you. The next item is innovative alternative technology for new constructions. Dan Ojala, PE, representing Down Cape Engineering, representing owner. Greystone Constructions, 75 Orlando Drive, Hyannis map parcel 270-241, proposed new constructions of IA secondary treatment unit. ST Star Systems with secondary treatment unit / IA component for 2-bedroom single-family dwellings. Dan?
Good afternoon, Chairman Lee, members of the commission. Again, Dan Ojala from Down Cape Engineering. I'm a surveyor and civil engineer and helping Greystone out with a new construction house on a smaller lot over here on Olander Drive. It's one that has a bunch of soil testing. Dave Stanton has been out there both times, once in '24, and then we redid another hole to check in '3/7/25 when we pulled in the job. It's in a nitrogen-sensitive area. It's a state zone 2. Your regulations allow a 3-bedroom on a small lot, and it's probably also in the saltwater, which is similarly, but if you look at the chart of wastewater discharges that someone nicely worked up for you folks a while back, I think Tom was involved, but on a smaller lot like this, if you use an IA that can do the 660 gallons per day per acre, then 2 bedrooms would be allowed under the state code, and again, it's allowed under your bylaw. Your process is that you like to review these systems when they come in, so it's not a variance, but it's a look at the plans, make sure everything is in order. This is one of the newer, best available nitrogen-reducing technologies. Again, it's a Septitech Star 0.5. So it's a new 2-bedroom, single-family on 15,000 feet. We got a 1,500-gallon dual-compartment tank, 1,000-gallon tank after that, which houses the Star unit, and it's a pressure-dosed leaching field. The Star unit has a little pump in it, which allows dispersing through a pressure-dosed leaching. We did hit models on this down a ways. It was very close to what they encountered. Jack Maloney did in '24. The elevation of the groundwater, Title V says to look at the models very carefully, and if you can get that level, that's what you use. Secondarily, you go to the well readings. And so we hit that at 26, and you see we've got a full, at different levels, but it's soil models at 28, and we've got the full 5 feet above that. That's test holes 3 and 4. We're both the exact same. So full 5 feet above the models. And again, you wouldn't expect the groundwater to come up there regularly, but every once in a while it does hit that level. So for the most part of the year, and most years, it'll be more than 5 feet of separation. And again, you've got that very decent treatment where we're stripping a lot of the nitrogen out of the waste stream. So we included with it the modified certification for general use for this, again, it's the best available nitrogen reducing technology. The letter outlines you've got to have it a certified operator. You're allowed 660 gallons per day if you're hitting the 19 milligrams per liter on the effluent. You've got to have a grade 4 operator, and who is also an approved Title V inspector, so not any Joe can operate this system. You've got to get a good operator, signed O&M agreement, and again, you don't have to flow meter it, they say, but the inspector will check the water meters. If there's a sprinkler, would advise the client to run a secondary meter on that, or at least get a good estimate of the amount of time. Most of them are all computerized now, and so it's pretty easy to check the use of the sprinkler. And the inspector shall inspect the system quarterly for the first year, and then 2 times per year thereafter, all in accordance with the approved O&M, the designer's O&M, and any special requirements that you have. And if there's an alarm event, obviously they'd want to do an inspection as well to make sure that there's no issues with the system. And then that's submitted yearly. So, yeah, there's no wetlands within 100 feet. There's no variances requested. The STAR is rated for 660 gallons per day per acre at 19 milligrams per liter. It's one of the only 2 technologies that's recently categorized as the best available nitrogen-reducing technology by the Mass DEP. The microfast unit isn't too far behind that, I was noticing. I did some looking at the studies, but this edges it out and was selected. But for those reasons, would respectfully ask you to approve the inclusion of the STU IA component as part of the septic design on this new construction, and I'd be glad to answer any questions if you have them.
Thank you, Dan. Any public comment on this one? None? Staff?
Staff has no objections to granting the variance for a STAR innovative system at this site. Thank you.
Thank you. Like Dan said, this IA system is permitted under the general use with the DEP, and it has the approval letter. So the only condition that I would mention that would be to sign the O&M contract for the monitoring as specified under the permit.
You need a signed O&M contract.
Yeah.
Yes, yes.
Yeah.
Yeah, prior to occupancy, or, yeah.
Any question from the board member?
So this system says it's good for 660 gallons per day per acre. So this is 15,000 square foot lot.
Yeah.
So that's
The acre is, by the way, a 10,000 foot acre. They tweaked the math a little bit. I don't know if it made a difference on this one, but it's a 10,000 foot acre. So the way I remember is 440 per 40,000. That ratio is what you can get. So if you multiply that by 15, you're just okay. It's the arithmetic is right here.
so they've got
You'd be okay on a 13,000 foot
330
lot.
gallons per day.
Yeah, well, your 330 rule has an exception for isolated lots that allows a 3-bedroom no matter what. But going back to the state code where you can do 660 per 40,000, it's in this box on if you have the plan. So you go 660 divided by 40,000 equals 0.0165. 220 divided by 0.0165 is 13,333 square foot required for the 2-bedroom. We have 15,000, obviously in excess of the 13, so it's okay. We do have to, hit the 19 parts per million, but again, this system is capable of it when properly run.
And you do have a reserve area outlined on the plan.
Luckily, we do, yes.
Yeah.
I assume we
Do you
do.
need deed restrictions for 2
Yeah, it's in the back.
Notice that too.
Yeah, yes.
noticed that too.
I recommend, yes, I believe it's required. 2-bedroom deed restriction required. under-
100%, yeah, and a notification of the IA on the deed. Yeah, I believe that's still
There
required.
it is.
Could I have a motion to approve the variance request with the following conditions? One is the deed restriction for 2-bedroom, and second, a signed O&M contract for the system, for the IA system.
So moved.
Second. All in favor?
Aye.
Aye.
Thank you.
Thank you very much, appreciate it.
And you want a plan?
Yeah, I guess couldn't hurt.
Thank you.
Yes. The next item is the sewer connection extension request. Dan Mosley, owners, 503 Strawberry Hill Road, Centerville, map parcel 248-021, phase 1, SEWH-24-73, requesting second extension to connect to the public sewer for additional 6 months. Are you Dan?
Yes, sir.
How are you?
Good, how are you?
Not bad. Go ahead.
Well, I'm redoing my foundation, so I didn't want to hook up to the sewer and then have to disconnect, dig out the foundation, do all that, and then reconnect. That's basically it.
The house right on the corner there?
Yes.
It's logical. Reasonable. I know.
Yep.
Just for clarification, let us know which, do you want the clock to start now or from the last extension expiration date?
I think
I
we
s-
need till December 1st, I believe, is about 6 months. I mean, I don't know the math in my head.
Why don't
I mean,
why don't
it's up
you
to the
from
board.
the previous 6 months? I
Just
mean,
wanna make
from
sure
the
he has
previous
enough-
notification stuff.
Yeah, I just want to make sure he has enough time.
Right.
I don't want to shortchange you.
When does the first one expire?
That was, I emailed you that date. I mean, I just have to look it up. I mean,
Like
he was,
June
he was
5th?
ordered back in June 4th of 2024, so it expired December 4th. That was 6 months, correct?
Right.
No.
January 4th, 2024 was your first, was the first 6 months.
So-
Then we,
So can we
Granted
extend it to
six-
January 1st of 2026? You
Yeah.
said December is when you're going to be,
Yeah, I'm gonna cap my septic October 1. So, and then I'm gonna do all the work. They said it's
When would-
2 months.
How long would that take
Oh,
to
2
do the
months.
house?
I gotta move out of the house for 2 months.
Yeah,
And then, so December, beginning of December would be the
Mm-hmm.
hook back up.
how about a
Why
little
don't you
wiggle
give me
room
9
until
months
January
and
1st,
recover it?
2026?
Why don't I give you March 1st, 2026?
Right.
Sure,
So moved.
sounds good.
You need some wiggle room because I'm not that good of an estimate in terms of constructions.
Yeah, yes, sir.
So any public comment on this one? Staff mentioned it. Could I have a motion to approve the extensions request
moved.
to March 1st, 2026?
Second?
All in favor?
Aye.
Thank you. Good luck.
All set?
Yep.
Thank you very much.
And then is the sewer connections, alternative road connections request. Alan, the first one is Alan Morrell, trustee 35 Nomus Lane, Centerville, map parcel 230-101-001, phase 1, SEWH-24-308, requesting extension to connect to public sewer for alternative route/road. Good afternoon. Good afternoon.
Mr. Chairman, good afternoon to you too.
You.
Board, we appreciate being put on your agenda today. Ladies, thank you very much for.
No problem. Why don't you sit down and sign your name first?
Sit here.
Yep.
Again, thank you so very much for including us. On
Make sure the mic is on. Your light is green.
Light is green,
You just push the button. It's green.
light is green.
Okay.
Again, thank you for putting us on your agenda. We fully support the big effort that you're making here to provide a sewer, and your team that you have is top-notch. Every time you call, you get excellent support. I want to thank you for doing that. Our purpose today, you read about, we're attempting to.
I just got a call. Make sure your mic is on and speak to the mic because they cannot hear you upstairs.
Test, 1, 2, 3.
Can you hear?
It's a little better.
Okay.
I don't think it's on.
Speak to
think
the
it's
mic.
on.
Yeah.
Got it, speak to the mic.
Is your green light on?
Green light is on.
Okay.
Sometimes it looks like it's on, but it's not.
Looks looking good, yeah. Maybe, I don't know.
I want to just switch. There you go.
Again, test 1, 2. Oh, there we go. Green light does not indicate on. Okay. Thank you again. You're running a great program, and your team that you have put together is very responsive whenever we call. Thank you. As you just read, our intention in coming today is to ask for an extension for the purposes of changing the location for the connection to Loomis Lane versus Finney's Lane. Our concern with the Finney's Lane connection is the distance required for that connection is about 3.5 times the connection to Loomis Lane. And the greater distance we're concerned could cause a maintenance problem in the future. I heard about today you're talking to the engineers about the potential failure of their systems. So I was thinking the shorter distance would be a little more safer and logical. And obviously the cost would be more reasonable too. We appreciate your consideration for this. And are there any questions that I can answer for you?
Thank you. Any public comment on this one? Staff?
Staff has no objections, and also DPW wrote to us recommending that this request be approved. The property will require a grinder pump to connect to the sewer service provided to this property's Finney's Lane frontage. However, it should be able to flow gravity if alternative road connection to Loomis Lane is approved. Should the Board of Health approve this request, please ensure it is communicated to the property owner that a change of project will typically result in higher sewer assessment costs due to utilizing additional infrastructure. To review information related to the sewer assessment and available financial resources, refer to the homeowner's sewer connection guide available digitally on the website barnstable.waterresources.com. Printed copies of this are also available at various town offices, DPW and Health, etc.
So from
Another advantage too is if they hook up on Finney's, they have to have a grinder pump.
Right.
And if they hook up on Loomis, they don't have to. So, I mean, I think it was the wrong thing to make them hook up here anyways.
Right, right.
And the engineers said the same thing for both properties, that it made sense.
Same thing, yeah.
Okay.
Move to approve.
The connection
Second.
time is about 2029 to 2030. So that's what your time frame is for the Loomis project
Okay.
stuff. Okay.
Great. Thank you very much. Appreciate your time.
No problem. Oh, we need to vote.
We need a second. I
Yeah.
move to
Second.
approve.
All in favor?
Aye.
You're approved. Thank you.
Thank you very much. Appreciate it.
Oh, you got one more, don't you?
Yep, I got one
Basically
more.
the same thing.
Good afternoon.
Good afternoon.
I'm Patricia Morell. This is my husband, Alan.
Let me read that, the agenda first. Patricia Morel, owner, 491 Phyllis Lane, Centerville, map parcel 230-101-003, phase 1, SEWH-24-310, requesting extension to connect to the public sewer for alternative route and road. Go ahead.
I just wanted to correct the spelling of her last name. It's Morell. We're the only ones who spell it that way.
Okay. Thank you.
So 1 R, 2 L's, more L, so more L's than R's. So I'm talking about moving the location to connect 491 Finney's Lane, also to Loomis Lane. It's 340 feet, like 8 times as far to connect to Finney's Lane as it is to Loomis Lane. It's like 45 feet, so it makes a lot more sense to us, and it would be far less costly we believe. We actually have 3 properties we're connecting to the sewer, so we're trying to save some money.
Understood. Any public comment on this one? Staff?
Staff has no objections. Also, DPW recommends approving this request. The same information as on the previous. Wouldn't require a grinder pump, and the sewer assessment costs will likely be higher due to additional infrastructure. Same information that was just provided. Connection is anticipated in the year 2029 to 2030 at this property. With this route, I should say, a different road.
Any comment from the board member?
Move to approve?
Second?
All in favor?
Aye.
Thank you all so much.
Yep. The next item is the flood variances. We have 3 requests. The first one is Urian De Silva, contractor representing owner, Revivals Presbyterian Church of Cape Cod, 90 Hinckley Road, Hyannis map parcel 311-0343, requesting a grease trap variance from 310 CMR 15.2301, 322-3, and 901-15 of the Town of Barnstable Code to utilizing an under-the-sink grease inceptor device.
How you doing?
Hello.
We don't have a kitchen right there at the church. We're trying to get one, and then we was trying to get exemption from the standard grease trap. We was under if we can do one under the sink that's 27 by 27 for 10 gallons, and that's our request. We usually do snacks on Thursday and a breakfast on Sunday morning. And we were trying to provide like fast food or something that's more, to feed our community. So that's our request. The only reason we're requesting this is the cost-wise to do an outdoor grease trap. It will be way more to do one. And that's the only reason we request indoor one under the sink.
Thank you. Any public comment on this one? None. Staff?
Under the sink, that's a separate subject. This board cannot grant a variance. That's a state plumbing board code, 248 CMR 10.09, I believe is the number.
Yeah.
That's separate from this board. The reason you're here is because you're required to have an in-ground grease trap.
Yes.
And that's what the staff recommends at this property as we have at other churches. That's all I have. Thank you.
The other things too, this church is served by is connected already in the public sewer. And you know the comment from DPW in terms of the grease trap issues. So.
So how much cooking are you actually doing at the church?
We do breakfast on Sundays only, and it's just for 300 people. And on Thursdays, we just do a snack, but we're not looking to do any, renting the kitchen. It's a very small kitchen. It's just to, it's a very little, food that we're thinking to do. It's nothing major.
But I think the question is, are you making bacon, eggs, and sausage, or are you serving pastries?
Well, no, we're doing
What are you making?
hot dogs and, just a very fast food, nothing.
Breakfast?
I think that was for Thursday night.
Oh.
Hot dogs for Thursday night.
Thursday night and on Sunday it will be eggs and nothing. It's just a breakfast with coffee and a little like a Brazilian food, we serve breads and just a regular breakfast, nothing. Yeah.
But a regular breakfast generates grease when you make it.
Well,
That's kind of what we're.
Yeah, we serve a different breakfast for a community. It's nothing with a lot of grease and stuff. So it's not gonna be bacon and we don't do that for a breakfast.
But you are preparing the food in the kitchen, right?
Yes, we are.
For 300 people.
Yes.
That's a lot of people.
Yeah, it is.
Yeah. Yeah, we are.
It's not a household quantity.
Right.
No. Yeah, is that, it's missing from our package, the full menu, correct? It's missing from this package?
That's correct. That's,
We need to know, you said eggs,
Yeah.
and what else?
We probably do bacons and
Bacon?
we usually make breads and bakery like very not grease, a lot of grease and stuff like that. But the other thing I think we should not need a big grease trap is because we only do Thursday and Sundays, only 2 days a week. So we're not going to be every day cooking over there. It's just.
But the problem for the grease is still there. You're preparing so much quantity-wise. You would have a lot of grease to deal with, and you're connecting to the public sewer. And we all hear from the DBW how critical in terms of the grease trap to protect the sewer line. So that's what we have it to deal with. That's what we're facing. So.
Yeah, it's just, 300 meals at one time could overwhelm that system and let grease into the sewer system. Even though you're only doing it that one day a week where you have that large meal, it's a lot for, yeah.
Well, we have, what I'm saying is we have 292 seats, but we don't have, that means we not have, 300 people every day.
Yeah.
We have 292 seats, but, we're not cooking every day 300 meals. That's what we have as a seat.
what the people who are running the sewers worry about, and they gave us some pretty graphic pictures.
Yep.
Is the buildup that can occur.
Yeah.
And part of the problem is with the under-the-sink grease traps.
Yep.
They just aren't as good at,
Not as efficient
yeah.
for grease removal.
Yeah.
So I think this would be outside what we normally do. And it sounds like it's outside what we've required of other churches also.
Right.
Right.
Yeah.
So I
It,
think you're going to need an in-ground one.
Yeah.
For example, at my church, which is over in Osterville, we actually ended up, we just did renovations, and we went to just a warming kitchen.
Yep.
So that we wouldn't have all these requirements. And so the food is made elsewhere and brought in, and kept warm at the church. But we're no longer cooking in the church because if you're not cooking in the church, your seating capacity, I think, doubles of who can actually attend the church. According to the septic requirements. Don't quote me on that, but that's the general principle. And yeah, grease buildup in the town sewer system really is a major problem.
Right.
Yep.
Right. So I would recommend you go and look at the menu-wise and how you want to change and modify the menu so that some of the food can be prepared, bring onto the site.
And
Then you don't
And
have
use
to wash and all that
only
stuff.
paper and plastic.
Yeah.
No
Or
washing
prepared
dish.
to put in an in-ground grease trap.
Okay.
Yeah, I think,
Ground grease trap would be a minimum size 1,000-gallon tank.
Oh,
Okay.
yeah.
And that's only good for 160.
What?
How many seats is 1,000 gallon? You need a 2,000, right? Because it's almost 300 seats here.
Yeah.
292. Yeah.
Yeah.
right, but if you have some alternative solutions on how to, take care of being hospitable and serving people, that doesn't involve cooking all the food at the church, you don't have to worry about any of this.
Okay. I will. I will see what we can come up with and come back.
Yeah. So do we need
So
an
do we
extension
just
or
want to table this? Or
table it?
do you want us to table it or say no?
Huh?
Do you need us to take a vote?
I think I understand what you guys saying. I don't think I can come back with with the second plan and see what we can.
Yeah, you can come back, and then if you don't require this, if you don't require the septic requirements, you can just get the food. Do you need any food permit from the town?
Yes, we like them to come back so everything's in writing, because
Okay.
things change when it's verbal.
So
very
when you
easily.
come back, prepare a written manual, what you are prepared, what you're proposing.
All right.
And then the staff can review it.
Okay, we'll do that.
Okay.
Yeah.
Okay.
I would suggest either withdraw without prejudice or just continue, whatever, in this case, whatever.
If we continue for 2 months, is that enough time?
Yes, definitely. Yeah.
Okay.
Continue 2 months, okay.
Yeah. Could I have a motion
August.
to continue for 2 months?
So moved.
Second.
All in favor? Aye. Thank
Aye.
you.
All right. Thank you very much.
The next item is Robert Wagner, Centerville Historical Society President, 513 Main Street, Centerville, map parcel 207-048, requesting a grease trap variance from 310 CMR 15.2301 to utilizing an under-the-sink grease trap recovery device. Is Robert here?
And there's no menu here.
Doesn't
either.
look like it.
I'm not able to explain what his procedures are, so I suggest that this cannot be voted upon or discussed.
No, let's table it to next month.
So moved.
Second?
All in favor?
Aye.
What was it, continued for 1
Put
month?
a table for next month,
Yep.
and you can contact Robert in terms of getting the
Yeah,
more
because,
clarification in terms of the food menu stuff.
and how it's
that we're
being
proposing.
either cooked or uncooked or heated, he would have to explain all those things.
Right, right. The last item is Robert F. Mills, the lawyer, Esquire. Princey Mill Law PC, representing owner, Grove Streets Realty Trust and Frosic Ice Creams, 3821 Falmouth Road, Unit 3A, Marston's Mill, map parcel 057-004, requesting a grease trap variance under 310 CMR 15.231 to utilizing an under-the-sink grease recovery device. Good afternoon, Robert.
Good afternoon, Mr. Chairman, members of the board. My name is Robert Mills. I'm an attorney with the law firm of Princey Mills Law here in Hyannis. Here with me is Weston Stahl, who's one of the principals, and Oscar Milan. We are seeking a variance under, as you know, under 15230 of 310 CMR. Those of you familiar with the property at Windmill Square know that there's about 10 buildings there. This particular building is Building 3, Unit 3A. The system that services that building does not have a grease trap. We are proposing to open up an ice cream shop serving homogenized ice cream that's being provided by Cape Dairy. There'll be no cooking on the premises at all. We do intend on selling prepackaged baked goods. There is no seating asked for, and there's none requested and none present in the building. We've made most of the stops along the way already. We've been to the Board of Health and have applied for a food permit. We've been through site plan review successfully and completed that. We had hoped to have accomplished Board of Appeals. We appeared for a meeting last week and the elevator was out, so that was continued to the 25th of this month. But otherwise, we've made all the appropriate stops and look forward to getting that special permit from the Board of Appeals on the 25th. We do have a proposal for a under-the-sink grease trap. I think we've provided you with a copy of the model. And it's actually, coincidentally, is the same that was approved at that location previously. You might recall that there was a caviar shop approved there previously. There was when my client leased the property a couple of months ago, there actually was a under-the-sink grease trap there. The former tenant removed it for whatever reason, and so we're looking to reinstall it and operate the ice cream shop.
Is this the unit here? Is it called the Zern
Yes, that's correct.
GTS 2700.
That's accurate.
It's actually a grease interceptor, just for the
Interceptor, yeah.
clarification. Yeah. If anybody wants to see the copy, it's not a grease recovery device, which is fine. It's a grease interceptor. Just a different type.
Yeah. Any public comment on this one? Staff?
Staff has no objections because actually a grease recovery device wouldn't be beneficial in this case because with homogenized ice cream, it just doesn't work. So we're fine with a grease interceptor, which meets the plumbing code under the sink. Still, the question of the in-ground grease trap is a question. It's not on sewer. It's a septic system at this property, so it's totally up to the Board of Health at this time. Sewer is
20 years out, at least.
Yes.
10 to 20 years away, and the board, we could warn them that the DPW mentions at that time they need to fill out the pre-treatment survey with water pollution control. They may be required to put an in-ground grease trap at that time. But perhaps you could condition the motion that way.
Right.
To re-examine when sewer becomes available. That's all I have. Thank you.
Okay. Question from the board member?
Move to approve.
Move to approve.
Can I ask a question?
Yeah.
What is the cost of something like that? Do you know?
Of the interceptor?
Yeah.
$746.
Yeah, that's about right, yeah.
How much?
Yeah,
$746.
yeah. But
I
that's
was gonna
not,
say, because if the sewer comes, you have to have a.
It'll be worn out by then.
That's 10 or 20 years,
Yeah.
might never get there.
Yeah, it's 20 years before we can see the sewer because I live in the neighborhood, so I know.
yeah.
So the only thing is that before you connect to the public sewer, you kind of fill out those pre-treatment inquiry in terms of with the DPW. So we can give you the variance up to that point.
Thank you.
Before you connect to the public sewer.
Appreciate that.
Could you include in the motion that it expires upon availability of public sewer in the letter?
Yeah.
Okay.
Yeah.
This variance would expire and
Is it
whenever that's.
necessary?
Well, the in-ground, it's not about the end of the sink. That's the
Once the
plumbing
sewer
code.
shows up, you're under a whole different
Correct. That's why it
circumstance.
expires.
Yeah.
Yeah. So,
That's why they expire at that time.
yeah.
Yeah.
I mean, doesn't it happen automatically?
No.
Oh, all right. Okay.
So,
Could I have a motion to approve with
So
the
moved.
variance request
Second.
and then expire before we connect to the public sewer? Second, all in favor?
Aye.
Thank you.
Thank
Good
you.
luck.
Thank you.
Good luck, yeah.
Next one is temporary housing request. Carlo De La Graza, owner representing Flip Circus and Simon Properties, 180 Farmers Road, Hyannis, map parcel 311-001, requesting approval for a 5-year RV temporary housing agreement for annual Flip Circus temporary events for staff. Hello, Carlo.
Hello, good afternoon.
Good afternoon.
Thank you for your time and allowing me to come here before you today to request approval for this variance for our housing for our circus staff and our clowns.
Any public comment on this one? Staff?
Staff has no objections. The applicant also requests that you approve it for 5 years. That's totally up to the board. We have no objections to that request either. Thank you.
Thank you. Any question from the board member?
no.
Move to approve.
Second?
All in
How
favor?
about you want to?
5 years.
For 5 years, yeah.
For 5 years.
Yes, sir.
Thank you.
Thank you.
Good
You all
luck.
have a good evening.
Should have been first on the agenda.
It's hard to know, isn't it? Yeah.
The last one is the pool variance request. This is a continuing from May 27. Dakota Capillaris Otis, manager representing Everleaf, Cape Cod and Communication Way apartment owner, LLC 265 Communication Way, Barnstable, map parcel 314-044, request for lifeguard exemptions, state sanitary code 105 CMR 435.23. Good afternoon.
Good afternoon. Thank you so much for your time this late in the evening. I appreciate it.
Yep.
I'm returning to you today from last month. I'm pretty sure you guys will remember, but we went through a sale in December and are looking at the variance. It was dependent on a couple, the water test and the site inspection, which we have initiated, and the results have passed and come back, and just a follow-up meeting to further discuss, I believe.
Right. Any public comment on this one? None? Staff?
I'm aware, as of today, the inspection, yes, the water quality has passed. The flow meter needs to be repaired. You could probably answer to that.
Yes, certainly. So the flow meter was something that the Board of Health Inspector, Catherine, put on my radar on Tuesday of last week. She did mention that it was, well, from what I remember, she said that it was something she pointed out last year, and it wouldn't stop us from passing, but it was definitely recommended. On site, I immediately reached out to our new pool vendor who we're working with to request a visit and a quote. My understanding on not that I have a great understanding on the pools, is that the pump doesn't have a variable speed, and it's something related, but I can commit to you that I have already reached out to have a vendor come to quote us for it. It seems like a pretty minor thing that should be very quickly rectified, you know.
I understand that's separate from the lifeguard variance request anyhow, but should be addressed this year, not continue.
Right.
My opinion is the same on the lifeguard question, that over 220 units should have a lifeguard. That's staff's opinion on this. If I know that there's a policy from the Board of Health, if you have 90 units or less, you don't have to have a lifeguard. And if in that case, you have to have 2 persons on site that are certified CPR and first aid. My concern is if you allow for that, with such a large, you have at least 2 buildings with 3 or 4 stories. If someone is on another building on the 3rd or 4th floor and someone needs immediate assistance in the pool, how is that helpful to call that person that's in another building on the 3rd floor? So I don't agree with that requirement. That's what the policy says.
Okay.
That's all I have. Thank you.
Staff, the board member, any comment on this?
You know, a few years ago, the lifeguards at the Tara Hotel, which is now the Irish Village, those lifeguards used to do lifeguarding at Everlake. But last year they didn't do it, and I guess this year they're not doing it. But they did have lifeguards at one time.
One time, teenagers had summer jobs.
Huh?
At one time, teenagers had summer jobs.
Wow.
Yeah, is there a manifest injustice in this request for variance? I haven't heard it, if there is. What is what is the injustice if the board doesn't grant this variance? Do you have specific reasons?
Well, I would say that the community at Everly was able to enjoy, from what I understand, and please correct me if I'm wrong, the last 2 summers to be able to enjoy this and this setup. Coming in as new ownership in December and initiating the pool permit for the season, we learned that the variance does not automatically transfer over. We immediately move forward to get that up to speed. I would say that if granted a variance through the remainder of the summer, as a new manager, somebody with a new ownership, I fully actually agree that I operationally, it makes much more sense to return to the lifeguard model, just given the amount of, the availability of vendors on Cape Cod and the past precedent. I would hope that at the very least we could find an arrangement for a variance for the remainder of the summer, subject to, I would be happy to overshare, the testing 4 times a day, random inspections. I will appear next month. However, I can give confidence to the board that we will handle this correctly according to the variance for the remainder of the summer. But I will say that I tend to side with you all, and as the manager of the building moving forward, it just makes more sense to go back to a lifeguard model because it allows the pools to be open longer. It takes the stress off my maintenance team, and they can go do their primary function rather than cleaning filters. So I'm actually very vocal to our new ownership that I support going back to the lifeguard model. I think that you even mentioned it last meeting. The last 2 summers under this model, they got off to a little bit of a late start. So I think it's all the reason to return to that lifeguard model. I would just hate for the community to not be able to enjoy the pool for the rest of the summer through no fault of their own. And again, I can commit that everyone on team has adult, child, CPR, first aid. We were all over this inspection this year, and however I can continue to improve the relationship between Everly and the town, whether it be with Boston Fire, it's my last job, Barnstable Fire Department, Board of Health. I am fully committed to being receptive to whatever you pass down.
Thank you.
Absolutely.
What about being able to get some of those, qualified swimmers or something, somebody who can do the dog paddle but would be there?
How deep is the pool?
4 feet.
4 feet. To further that, there's a program for the qualified swimmers for our community. There's a lot of there's a lot of individuals who love to contribute, who are able to contribute. We first double checked with our legal and then with the town that we are able to. Essentially, what we're going to be doing now that we got the approval is we have a small roster of very qualified residents who want to participate. We are also paying to get them an additional CPR certified just to bolster those numbers. It is a very large building, to your credit. I know exactly what you mean. It's very long. It is only one building, to be fair, but I totally understand your concern of, put a stopwatch on and you're on the 3rd floor as a maintenance guy getting to the pool in the slower elevators. I totally understand the concern. So we're doing everything we can to up those numbers. And generally speaking, the entire office staff, that it is very close to the pool, and we don't really leave. So we have an activities director. We just hired an assistant property manager adding to the staff. She just started last week, so we're going, to closer to 8 employees. And I really do feel as though, looking at last year's variance, which is all that I have to go on, I read through it very carefully. I looked at the requirements. I printed out last year's inspection. I walked it with the team, and I'm very confident. I commit to you that we can continue throughout the summer adhering to everything that is in there. And of course, next summer, if you guys would like to review it again next summer, I would totally understand that if it's just a temporary thing.
I think you could even hire some of your renters. Somebody can walk at least, and be able to.
I think that's what he was just talking about, is having some of the residents.
Absolutely.
But the use of the pool is actually also a very effective physical therapy. It's a 4-foot deep pool. They can drown in their bathtub too.
Yeah.
To take away an effective form of physical therapy for a population that needs to keep moving and can get good exercise in a pool doesn't make any sense to me, especially when it's hard to find lifeguards. And lifeguards, and to be honest, I'm not sure it's a good use of their money either. These are all adults. It's a 4-foot deep pool, and
right, you don't need a swimmer. You need someone that could walk in the pool and help.
Yeah.
And we do have, naturally, as part of the requirement of the inspection, we do have the emergency call button that was tested and working. And also, further to your point, Doctor, we do have, contingent on the approvals here. We are lined up with water aerobics classes that have been enjoyed in the past summers. We do 6 classes a week that are, balance, mobility, walking outdoors. And a lot of people are looking forward to the water aerobics coming back. And also to be upfront about how serious I take it personally. I have closed the pool for the weekends, and so we just recently passed the inspection on a Thursday at like 11 a.m., and we're given approval to open that Thursday. We closed on the weekend. We're closed this weekend. It's beautiful. People are very upset, but what I say to my residents is if we're not clean, if we're not compliant, we're not opening, and that's that. So I'm really grateful that we're able to do Monday through Friday right now. But if we can't open, if I can't follow the rules on the variance, I will close that pool. You know, there will be
And
no
the
risk.
cleanliness and keeping the water pristine is I think, far more important.
And I did bring some test records. Again, I understand in the past, who knows? But I can tell you about the future, and if there's anything I can do to share those in any way, I just want to be a good partner in it.
What was the previous conditions under that permit?
I don't think there were, it was just a waiver so that they didn't have to have a lifeguard. I think we've kind of gone down some rabbit holes this time.
Well, like I say, one year or 2 years, there was lifeguards from that worked at the tower, too.
Is there a second page?
But I mean, you just have anybody, somebody.
You want me to read the conditions, or no? You asked the question, right?
What conditions for the lifeguard or the qualified CPR guy?
For the variance from last year?
Yeah.
They have to post a sign warning no lifeguard on duty. Children under 16 should not use the pool without a responsible adult. In attendance, no alcohol allowed in the pool area. Maximum occupancy is 19 persons. Adults shall not swim alone. Number 2, access to the pool area can only be granted by a key or key card. The swimming pool gate shall be locked or monitored by the pool operator at all times the pool is open. Number 3, no diving boards, slides, or other appliances authorized in the pool area. Number 4, pool hours shall be no later than 10 p.m. 5, no organized or scheduled special events or charitable events. Example, belly flop contests. Sorry. We actually had that in the past at another location. Not assisted living.
Maybe a trader is.
Yes. Number 6, at least 2 staff members with adult and child CPR certification shall be on the premises all times the pool area is open. Number 7, you shall maintain a 4-foot walkway free of any obstructions around the perimeter of the pool. The variance is not transferable. This letter shall be laminated and posted at the wall for inspection, for viewing during inspections. So,
That condition sounds.
Sounds great. Yeah.
Should we approve it for a couple of years, or?
Move to approve the same variances for 2 years.
Okay.
Seconded.
All in favor?
Aye. Thank you.
Thank you all very much. Look
Thank you
forward
for your
to.
patience working with the staff.
What's that? I'm so sorry?
I said thank you for the patience and working with the staff.
Thank you. Thank you.
Straight.
Absolutely.
Water quality.
Absolutely. I think everybody will see moving forward, the Everly will be very compliant. And I'm always happy to come back if there's ever anything in any way, shape, or form. Just want to be helpful.
Okay.
Thank you.
All right. Thank you, everybody. Hope you have a great night.
Yep.
Thanks for staying late for me.
We have one set of minutes from May 27th. Any question on the minutes?
No question.
Can I have a motion to approve the meeting minutes?
Motion to approve.
All in favor? Aye.
Aye.
Our next meeting is July 22nd. Could I have a motion to adjourn?
Second.
All in favor? Aye. We are adjourning at 6:23.